Ronda Hicks, administrator of the estate of Paris Hicks, and owner's insurance company versus Lovers Lane et al., correct? That's the first case?
Ronda Wicks. It's Ronda Wicks.
Wicks, yeah, okay. Thank you for that. Each party will have 15 minutes to present their arguments. Of course, the appellant may reserve up to 5 minutes for rebuttal. And as you probably know, these are videotaped, so please try to remain at the podium and keep your voice up. And other than that, I think we're ready to go. We've read the briefs and we're ready to go if you want.
Yes.
All right. Let me know if you want to reserve any time, please.
I'd like to reserve 3 minutes.
3 minutes.
Your Honors, may it please the Court, my name is Ken Myers, and I'm here on behalf of appellant Ronda Wicks as administrator of the estate of her son Paris Wicks. This is a premises liability wrongful death case. The facts are fairly clear and undisputed as far as the event. Paris Wicks was a 23-year-old young man. He walked into a convenience store called Lovers Lane Market in Akron on August 29th, 2013. Middle of the afternoon, went in to buy a t-shirt, was robbed and shot and was killed very tragically. And the question generally before the court is whether Lovers Lane Market has any liability for taking part in Paris Wicks' death. It's the appellant's contention that this convenience store was basically a gang hangout. There's two issues. One is, does the evidence show that there should have been foreseeability? And there's a separate procedural issue basically with the admissibility of a key piece of evidence, which was a store videotape, which was confiscated by the police and used in criminal trials. And I think even without the video, there's substantial evidence that there was foreseeability that this store not only permitted these known gang members, most of whom had violent records, to not only hang out at the store, but several of them actually worked there under the table. And they were, it was a drug hangout. The defendants themselves, the convicted defendants, I'll call them, as opposed to the corporate defendants, admitted that they bought and sold drugs there. Several of them were high or drunk on the day of the incident. The store...
Now, they admitted that. Was there any evidence that the LLM knew of these things?
Yes, well, the manager testified that 10 to 12 times a day, if not more, he would shoo these loiterers away from the store, but they kept coming back. He testified that they threatened him, testified that he had a gun on him at all times. The owner had a gun behind the counter. This was, the police officer testified and the councilwoman testified that this was a known drug hangout. Now, I know drugs doesn't necessarily relate to or create an impression that there's going to be a murder there, but this was a dangerous place, and even though the management professed to know nothing about who these individuals were, it's clear that the employees were employing them under the table, supposedly, but certainly on the day of the incident, they were all just hanging out there for hours at a time. And again, they testified that they would regularly hang out there and that they would get high and come in and just hang out. Now, if we get to the videotape, which the court excluded, apparently didn't even look at under, I believe, a wrongful interpretation of Rule 56, then there's even more evidence, and it becomes quite clear what the atmosphere was of this convenience store, both before, at the time of, and the immediate aftermath of the murder. What I find to be some most chilling evidence that's in this video is that just a couple minutes before the murder, the manager of the store can be seen on the video, and there's an argument to be made that he was actually getting high with these thugs that had taken over the store. Now, of course, he denied it, but you know, if you look at it from a totality of the evidence perspective and looked at in a light most favorable to the plaintiffs, certainly a jury could draw an inference that that's what's happening, that this thug culture that existed at this store should have tipped the owners off. I mean, when the current owners bought the store in 2012, they installed a 16-camera video system, excuse me, and the manager testified that he could see what was going on outside the store, he could see what was going on inside the store, and so he knew. That day, they were supposed to videotape a rap video, and the police officer testified that these rap videos were often used and put online to signify the gang culture and to show gang colors and symbols to basically stake out their turf. So I think it would take a person who's willfully looking the other way not to see what was going on in this store and around this store, and to let it happen. And Paris Wicks, who was just a good kid that walked into the store to buy a T-shirt, had no way of knowing that he was walking into the lion's den. And I think if you envision, walking down a street, walking into a neighborhood, and all of a sudden you get this feeling like, uh-oh, I'm in the wrong place. This is dangerous. And I think that's the impression that one could get walking into a store like that, not knowing that it belonged basically to this gang. And the police officer for the city of Akron testified that this was a particular gang. Now, there's no evidence in the record that this was officially their headquarters or their hangout, but the gang members themselves testified that they would go there several hours a day. They would hang out there. You can see they're hanging out there in the video. So I think on the substantive level, there's plenty of evidence to create a genuine issue of material fact that should have sent this case to trial. Briefly on the issue of the admissibility of the video, the judge basically just said it's not within the enumerated types of evidence in Rule 56, therefore it's out. And there's obviously, I've cited in my brief, a whole body of case law, including from this court, that says that videotapes and photos are admissible. They have to have certain standards, including authentication, but that bar is very low. The Ohio Supreme Court has even created something called implied authentication. And the basic point of authentication at the summary judgment level is just to create some evidence that the tape or the photo is what it says it is. That it purports to be what it depicts what it purports to depict. And there's plenty of evidence in the record, and I've cited in my brief, that this tape is what it purports to be. The employee and the manager of the store identified several people during their depositions from the video. There's really no dispute that it is what it purports to be. I think the dispute by the defendants is basically that the magic words weren't used, that we didn't close the loop and say, bring someone in to say, here's what it is, here's what it was, when it was created, here's the chain of command, the chain of evidence. And I think those are, first of all, they're not necessary, because what the Supreme Court has said is you just got to get over the bar of proving it's not a fake. And no one's ever said it was fake.
Let me stop you for a second. I know it was an exhibit with Linda. Which deposition was an exhibit for?
It was an exhibit for both the manager of the store, Mr. Samad, and the employee, the guy that was running the cash register. And we showed various clips from that for them to identify people and for them to identify the surroundings of the store, so to physically identify the store. And I included a sort of a guide because the tape is kind of complicated because there's 16 different views, and so I included basically a guide of the highlights so the court wouldn't have to look at an hour-and-a-half long video 16 times to get all the different views, because there's only certain parts of it that I made reference to in the summary judgment brief that I thought were relevant. I think this court has a decision to make whether to presume the admissibility of it and remand it back to the court for trial, or to say we need a decision from the court in the first instance, from the trial court, on the issue because it wasn't briefed at the trial level. The court just made a decision sua sponte without even proper argument being made by either side as to its admissibility. Certainly, my best case scenario would be that the court said, we've looked at the tape, it's admissible, it creates a genuine issue, go forward with trial. But I also understand appellate court procedures, and the court may not want to go that far, but I think the case definitely needs to be remanded, because for the trial court to dismiss it out of hand using the wrong standard, I think certainly it was a key piece of evidence, probably the key piece of evidence, and it certainly prejudiced plaintiffs in their ability to show there was a genuine issue. I don't know how I'm doing time-wise, but...
You have a total of 4 minutes and 40 seconds, so.
Okay, I'll...
About a minute 40, or you want to stop now?
Yeah, if the court doesn't have any questions now, I'll reserve the rest of my time for rebuttal.
Okay. Yeah, 4 minutes and 28 seconds.
May it please the court. My name is Rich Treasy. I'm here on behalf of Lovers Lane Market. Some points of clarification just before I start out. I think the second assignment of error is limited to the videotape, not anything really beyond the videotape. And in terms of the allegations as to these people who were hanging around the store, they were not employees. There's no evidence in the record that they were employees or that Lovers Lane knew they were working there. It was basically a cover, and in fact, plaintiff even states that in his brief that that was a cover on page 16 of his appellant's brief. And there's no evidence connecting them to us as employees in terms of Lovers Lane. The shooting, please keep in mind, was not in the store, it was outside. The implied authentication, the Supreme Court didn't actually hold that. In the decision, which is Midland Steel, the court first said, page 130, about implied authentication that it was, but then it went on and said, in addition, the fellow testified that he was a custodian of the videotapes, that he knew of no method of altering the videotapes, that he had not altered the videotapes, and the videotapes accurately depicted what he had seen while personally monitoring the surveillance system. So that's quite a bit more than implied authentication. That's actual authentication, and that's why the Supreme Court found it. In terms of the videotape itself, it wasn't actually marked in any of the depositions. It's not attached as a marked exhibit. There's nothing connecting the video in the depositions to the video that was filed. Perhaps that could have been done in a number of ways, but that was not done here. In terms of the first assignment of error, first of all, we did object in our reply brief. We specifically did so. Second, there's quite a bit of reference to not objecting in depositions, and of course we couldn't object in depositions based on local rule 17.02 of the Summit County Court, and of course Civil Law 32 also preserves all objections. So there's no need to object, and in fact we were precluded from objecting. Regardless of objection, of course, the trial court had discretion to accept or exclude evidence that was not properly authenticated on summary judgment. And that this court has held in numerous cases. They're cited on page 10 of our brief. The court may but need not consider, and in fact, the Third Appellate District has held that it's not mandatory that the court consider evidence that is not properly authenticated. And this court has again held may but need not consider. is a video, in terms of the videotape being authenticated, it wasn't authenticated. There were 3 persons that were cited. They never viewed the whole videotape. They never authenticated the method for recording, which would be the silent witness theory. Testified as to how it was recorded, how the various cameras worked, that it was functioning properly that day. So that method doesn't work. The other method is simply the pictorial testimony method, and that method is that the witness says, this depicts what I saw. And that didn't happen either.
Well, wasn't there testimony that they identified individuals in the store, they identified the store?
They did identify some individuals. They did say, this is that, but that doesn't, there are 2 problems with that. First, the problem
Location
is,
of people within the store, things like that?
that is true. They did do some of that. That being said, it's a lengthy videotape. And a few snippets of that's so-and-so, that's so-and-so, doesn't authenticate what was going on. And the reason it's being...
How about, did they go as far as that so-and-so who worked with me and was paid under the table?
I don't believe they went that far. I mean, they described who it was.
I mean, there's no question where the video was shot. I mean, it was clearly the Lover's Lane Market. That's not in dispute, right?
I don't honestly know. I mean, the video that was submitted attached to the summary judgment, or submitted separately from the summary judgment, was purportedly the one that was taken by the police. The one that Lover's Lane had was taken by the police. There's nothing linking the snippets that were shown in the depositions to the full one, apparently full one, which I don't actually know whether or not it's full because there's no one saying whether or not it's full. No one's actually testified to that. Is it the full deposition? Does it have all the camera angles? Is it snippets? Is it not snippets? I don't know what it is.
What about in the deposition, though, in regard to when they were talking about the video and they identified people and so forth? Did they also identify what people were doing in the video and where they were located, as Judge Tito's was saying, like outside?
I don't believe,
Was any of the video outside?
not that I can recall, I think it was all of people inside. There might have been some of the drive-through window. And I would hesitate, not hesitate to mention, but I would mention page 30 of the appellant's brief. They quote the testimony of one of the people that they're relying on, Etim, and this is from, would you tell us, look at them, that these are accurate depictions of what is happening? And then someone from Lover's Lane objects, and then the statement by counsel for plaintiff is, you are not sure. Do you recognize yourself? So this was not, this is the Etim depot at 24, it's cited, quoted, page 30 of their brief. And regardless, there's no connection between the depot and the video in the depot, the snippets that were shown, and what purports to be the full video that was taken by the police. There are a lot of ways that could be done, but it wasn't done here.
Counsel, when you say taken by the police, are you talking about the Lover's Lane Market video that the police had custody of in an attempt to resolve the murder cases?
Presumably. That's what's been represented to us.
So when you
I
say
don't
taken by
actually
the
know.
police, meaning they took control of it? Not they took the video?
That would be correct. That being said, I don't actually know whether that's the video that was submitted or not, because there's no connection. I mean, a police officer could have testified to it, could have submitted an affidavit, but that didn't happen. We don't actually know what that video is. Because it was taken, apparently, by the police. I mean, that's been represented to us. I don't actually know that. But, I mean, that would be the way to get it into the record. But In addition to that, the question is, does it matter? And that's the second assignment of error. And it doesn't, because the video at most shows the events on that day, even in the best case scenario. It doesn't show any preceding events or any notice or anything that would create a duty or foreseeability on the part of Lover's Lane.
Well, I don't think there's an issue that they knew there were people that were hanging. I mean, your guys testified to that. The owner testified that he kept a gun there and he was shooting people away all the time. So it's not like there wasn't awareness that there are individuals that should not be hanging out there. At the very least, it's a loitering.
At very least, it would be loitering, but that doesn't rise to the level of events that are somewhat overwhelming that would give Lover's Lane notice that there's going to be some kind of violent crime. I mean, there's
How
no.
about, counsel, the fact that participating in gang activity is a crime in and of itself? Is there a reasonable question of material fact in this case that it was more than just loitering, that it was actual active participation in gang activity?
I don't believe there's any actual evidence that these people were in a gang in the record.
Not enough for a question of fact in that regard?
No, I mean, even if there were a question as to whether or not they were in gangs, I think the standard would have to be whether or not it was foreseeable that there was going to be a robbery, violence of some kind, a shooting. And in the entire record, there is no evidence of a prior theft, a prior holdup, a prior shooting. There are no police reports, there are no police runs. There's nothing. I mean, there's no evidence of any kind of prior violent activity at Lover's Lane Market, say nothing to outside in the parking lot that would have put my client on notice to do something in addition to what they were already doing.
Which was what again?
Well, they were shooting people away apparently. But
Did
again,
you call the police?
I don't know that that's in the record, one way or the other.
Nobody asked them if they called the police?
I don't.
That's fine if you don't.
I
That's
don't
fine.
believe that's in the
That's
record, one way or the other. I'm not certain.
Wouldn't that be a good resolution to the problem that people that are, at the very least, we agree upon loitering there, which is not a good idea. Most shop owners or restaurants or whatever don't want people loitering around their premises because it's going to deter customers and you never know what's going to happen. So wouldn't it have been a good idea for, or even maybe even say responsible, to call the police to try to get these individuals to stop loitering at the market?
I don't know that that's the situation here. Whether or not that would have prevented loitering, I don't know. But in order to create the duty in terms of an event like this, I think there has to be probably more than loitering. Some kind of notice of a violent crime, hold-ups, some kind of...
How about notice of individuals loitering that are members of a criminal gang? Criminal gangs are, is there a presumption that criminal gangs are violent? When one of the members was identified as Monster, I think, even one of the employees said they were afraid of Monster. I mean, there's got to be some sort of an obligation on a store owner who permits loitering by gang members. That a violent incident may happen. Isn't that foreseeable when you allow gang members to loiter in your store without calling police? It's convenient to say there were no police reports if you never call police because you're allowing the gang members to loiter in your area. Of course you wouldn't call the police.
I don't think that number one, there's no evidence that we actually knew they were gang members. I mean, this is all post hoc.
Well, he was scared, that's the reason he kept a gun, right?
Well, he didn't say he was scared. What he said was that he carried it out of, because you never know what might happen. I mean, that's what he said. A lot of stores in good neighborhoods, bad neighborhoods, have a gun behind the counter.
Is there evidence he knew that this particular gang was centered in that area of town?
No.
I mean, that's pretty common knowledge, isn't it?
It's certainly not in the record. I mean, there's no evidence that anybody who was in charge of Lover's Lane Market knew that this was a gang, knew that these people were active gang members. There are allegations that there was drugs, that there were drugs being sold. There's no actual evidence that drugs were being sold. There are allegations that some loose cigarettes were being sold. There's no evidence that to support that either. All of the allegations in the brief and all the supposition is just that, it's supposition.
You can ask a lot of questions, you've got about a minute left, so.
Oh,
You
okay.
can heads up on that.
Okay, no, I welcome questions, by the way, of course, that's why I'm here. But again, so there's no evidence of any prior violent acts at all at Lover's Lane Market. In terms of assignment of error number 3, there were a bunch of other claims, wrongful death, and et cetera. That was kind of addressed a little bit in the briefs. And of course, if there's no foreseeability, then all of those fail as well. There's no proximate cause.
I guess I have one more question.
Please.
I don't remember this being answered in the briefs, but maybe I missed it.
All right. One more question, then he's out of time.
Oh, my. Anyway, did anyone ask the owner of what instructions he gave his employees to keep the loitering to a minimum?
I don't recall that being in the depositions.
Thank you for your argument.
Thank you.
4 minutes, 26 seconds.
Thank you. To respond to a couple of things that came up, on the issue of the foreseeability and whether there were police runs, I think, Judge Tito, so you got it right. They wanted to have it both ways. The manager testified that everything was fine, they never had to call police, everything was good. But he also testified not only did he have to shoo the people away from loitering 10 to 12 times a day, if not more, but he said he was threatened by some of these people when he tried to shoo them away, and he had to close the store down several times because of the loitering. He also testified, and you can see it on the video, that it's a small store. He said that only 2, 3, 4 people can fit in there at once. And so the video shows there's 4 or 5 of these guys inside and dozens outside. And he could see that. He could see that, he testified, he could see that on the video.
Did he actually say how many people he saw in the video?
No, he never said numbers, but he did say I had to shoot them away 10 to 12 times a day, if not more. And that when he tried to do that, they were threatening. So again, I don't know, I think it would be an incorrect ruling to say that you have to have evidence of another shooting and killing before you can hold the store owner responsible for the second shooting and killing. Everything was there, all the evidence, all the indicia was there of this store being run by this gang. And I think, Your Honor, you pointed out correctly that one of the other employees was afraid of one of the other guys, Monster. And he was one of the guys that supposedly worked under the table. So they can't have it both ways, saying, we didn't employ these guys, we don't know who they are, they don't hang out here. At the same time, I'm going to carry a gun, I'm going to have video, I'm going to close the place down, I can see what's happening outside. They have to bear some responsibility. And on the issue of the admissibility of the tape, again, there's been no allegation anywhere that any part of this video, whether it's the snippets that were shown in the depositions or the full video that was filed with the court, that any of it's phony or fake. And the idea that this case is going to get dismissed because someone didn't say this is the same video that was taken by the police as evidence the day of the incident. The manager testified in deposition when I asked him, is this the videotape? And he said, well, you have it, this is what was taken by the police that day. So he didn't even have a problem with it being the same videotape. So I think the defendant's attempt to get the case or maintain its dismissal because of the admissibility issue is really putting the cart before the horse, because there is no dispute that it's both the snippets and the full video are what they purport to be. And I think that any problems with authentication, or if the court wants a more broad interpretation, can be taken care of at the trial court level, either on some sort of remand, either another summary judgment motion with the tape being admissible, or with argument about its admissibility, or as a precursor to trial. The trial court can certainly say, I want a police officer to come in and testify that this is the same video that they took that day from the store, and I want the manager to testify, sort of closing loopholes, but that's all they are. I think.
Opposing counsel, right at the beginning of this argument, made a point that I'm curious to hear your response, and that is on assignment of error 2. Why you seem to limit yourself to the court's failure to consider the surveillance video. Because of that, the court failed to view the evidence in the light most favorable to the non-moving party. You want to respond to that?
I'm not sure I understand the
Well, you're saying that irregardless of the video, there's other evidence here that standing alone would require us to remand. I think he's saying the way your assignment of error is worded, you're limiting it to the court's failure to consider the surveillance video.
I think that it would certainly substantially weaken my case if the video was not deemed admissible, and that's why I think the case was dismissed. I did not, in the assignment of error, go chapter and verse into why there was a genuine issue of material fact, even if the video was excluded. So I think counsel is correct that in terms of the official assignments of error, I need that video in. But I wanted to give the court the background that video supplemented and augmented the existing evidence that coordinates and complements that video.
Okay, your time is up. I want to thank you both for your presentations today. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail each of you a copy of the decision on the day it's released, and the opinions are also posted on the Supreme Court's website. So thank you again for your arguments.
Thank you, Your Honor.
Thank you, Your Honor.